of Rahaman and another, and a sexual assault for the Home Department.
My ladies, my lord, I appear for the appellant this morning with Mr. Fazli. Mr. Evans appears for the Secretary of State.
Yes, thank you, Ms. Malik. If you just give me a moment while my computer warms up, it seems a bit reluctant. Just before we start, Ms. Malik, we've got certainly I have in front of me a skeleton argument. Is that a new skeleton argument?
No, it's the same one, I think, isn't it?
Oh, is it? The one we've already
Yes,
got.
the instructions were to bring 2 copies,
Ah,
rather
thank you.
strangely. Imagine, your ladyship, my lord, you already have those.
Yes, we do. Thank you. I thought we'd already seen them. That's fine. Thank you very much. Now, Mr. Malik, obviously we've all had a chance to read the papers, the grounds, and the basis upon which you've been given permission to appeal. It seemed to us, having had a chance now to reflect, that the approach that we ought to take, subject to anything that you might want to say, obviously, is to assume for the moment that the additional submissions that were sent a couple of days after the deadline, that they should have been before the First Tier Tribunal, and that the failure to achieve that meant that there was some sort of error, procedural or otherwise. But the central issue in the case is what difference those submissions would have made to the decision of the First Tier Tribunal. And speaking for myself, and I think for my colleagues, if the answer to that is no difference, then the other grounds fall away. And if the answer is that there is a difference, then obviously they don't. And so we'd like to invite you, please, you first, and then obviously the respondent, to argue in respect of that issue.
I'm very, very grateful for the indication. The upper tribunal accepted, at least tacitly, that there was some procedural irregularity in the sense that those submissions were not before the First Tier Tribunal in the circumstances when they were clearly sent and should have been before the judge when the decision was taken. The upper tribunal gave 4 reasons for concluding that those submissions wouldn't have made a difference. Subject to any observations, I propose to address those 4 reasons in turn. The first reason given by the upper tribunal was that those submissions contained a new matter and the First Tier Tribunal had no jurisdiction to consider it.
I think perhaps we're at cross purposes. The issue for us is whether, as a matter of fact and law, those submissions would have made a difference. The upper tribunal's reasoning in respect of why they wouldn't may be of interest, but it doesn't really matter. What matters to us, as it seems to me, as Lady Justice Andrews made clear in the permission, it is for us to decide what difference they would or should have made. So if you could perhaps frame your submissions accordingly, rather than being, if I can put it this way, perhaps at this stage distracted by the reasoning of the upper tribunal.
The real question is, could they ever be treated as giving rise to an historic injustice? Because the submission said there was an historic injustice in relation to the 2015 decision.
I see.
And that meant that your client should have been treated as if he'd been granted leave to remain, rather than being here unlawfully. But if in fact those submissions can't possibly demonstrate any injustice or historical injustice of that nature, then frankly the rest is not relevant.
So for that purpose, I take it that the court will assume, without deciding, that those submissions fell within the jurisdiction of the First Tier Tribunal. The First Tier Tribunal could have grappled with those submissions.
Well,
Yes. Yes, absolutely. I'm sorry, I thought I'd made that clear, but I obviously didn't.
I see.
That's the issue.
Yes, and I take it that the court will assume, for the sake of the argument, that the First Tier Tribunal was at least in principle entitled to depart from its decision made in 2015.
Well, the whole question is not whether it's going to depart from it. In 2015, an application for Tier 1 entrepreneur status was refused.
Yes.
It was appealed and dealt with on the law.
Yes.
This is an application that removal would be contrary to Article 8 and permission outside the immigration rules. And it's not departing, is it, from that earlier decision and saying we will now reach a decision that he's a Tier 1 entrepreneur, because he hasn't applied for that. And the question really is, how can it be an historic injustice when what has happened is the processing of an application properly, as far as one can see from the documents, in accordance with the rule, and an unsuccessful attempt to appeal and seek judicial review?
But
How could that be an historic injustice?
Yes. So I see the point. So what I propose to do then is to take the court to the decisions made below, and we'll then make some very brief submissions on that particular point alone, assuming that the court will proceed on the basis that my lord and lady has just outlined. So may I show you the decisions taken below? The court has already seen those decisions, but may I simply highlight passages that in my respective submission are of particular relevance. So firstly, may I respectfully take my ladies and my lord to page 152 of the bundle, where the court will see the First Tier Tribunal's 2015 decision. And in my respective submission, that ought to be the starting point to see what was decided in 2015. So you'll see that was a refusal of an application for leave to remain as a Tier 1 migrant. And the Secretary of State had refused the application, see paragraph 5 of that decision, on the basis that the appellant was not a genuine business person. He had failed to submit documents that he should have submitted, see paragraphs 6, 8, and 12. When the matter reached the First Tier Tribunal, the appellant sought to adduce fresh evidence, including a witness statement and documentary evidence in support of Tier 1 application that was not provided to the Secretary of State. That is clear from paragraph 21 of the judge's decision. And you'll see a record of the submissions that the Secretary of State made at paragraph 22. The Secretary of State argued that it wasn't open to the appellant to rely on post-application evidence. And you'll see that submission was accepted by the judge. Paragraphs 27, 28, and 29. The judge concluded that the evidence that was before the judge and was not before the Secretary of State would not have been taken into account. And that was the reason why the appeal failed. The appellant then, after making a few unsuccessful applications.
And that was correct on the laws that stood at the time.
Was, yes.
Yeah.
The appellant then, after making a couple of unsuccessful applications, made the present human rights claim, which was refused, as the court knows, on 8th of July 2019. That decision starts from page 131 of the bundle. Now you'll see a heading, Sporting Documents, at page 133. And under that heading, the Secretary of State sets out the documents that the appellant had provided. And you'll see that those documents included the previous appeal documents. This is the final bullet point. The application was refused, and it then gave rise to the appeal that triggered these proceedings. The decision of the First Tier Tribunal in the present appeal starts on page 115. And if you look at page 116, under the heading the hearing, you'll see that the judge summarizes the evidence that the appellant gave, and that evidence was given pursuant to a witness statement that was submitted to the First Tier Tribunal. And you'll see that in that witness statement and in the evidence, the appellant sought to resurrect the previously unsuccessful application.
How can he? He can't resurrect that application. It's been determined lawfully. It's been appealed to the First Tier Tribunal, dismissed lawfully. Permission to appeal was refused. Permission to apply for judicial review of the refusal was refused. Permission to appeal to the Court of Appeal was refused. So that was that. He was unlawfully here from the time that the appeal rights was exhausted.
Absolutely. But in short, the point that my predecessor sought to make was that a mistake was made in 2015.
But what mistake? The mistake was that he didn't provide the documents to the Secretary of State that he says would have established his entitlement to Tier 1.
Yes, and the Secretary of State took the view about the appellant, that he was not a genuine business person.
Well, that's the second reason why he wouldn't have succeeded, as well as not having the right documents as required. The Secretary of State and indeed the First Tier Tribunal didn't actually think he was a business person, but it wouldn't have mattered because he didn't provide the documents.
I think the fact that he was found not to be a genuine business person was because he had not provided the relevant documents. And the point made by the appellant was that a mistake was made in 2015, contrary to the conclusion reached by the Secretary of State and the First Tier Tribunal. Then he was actually a genuine business person. Now, this
even if he was a genuine business person, and there was discrepancies about the amount said to be earned, 147,000, and various documents that showed a much lower figure. Assuming that that's wrong, he still wouldn't have got Tier 1 status in 2014, 2015, because he simply hadn't provided the documents that he had to provide.
Well, he did not provide those documents to the Secretary of State. Of course, that is the case.
So where's the injustice or where's the historic injustice? Where's the wrongful operation by the Secretary of State?
Well, the Secretary of State, in absence of those documents, took the view that he wasn't a genuine business person.
He can't get Tier 1 status unless he A, produces the relevant documents, and also, in addition, satisfies the Secretary of State that it's a genuine business. And he never got through the first hurdle.
I accept that. I mean, of course, this wasn't an appeal against the 2015 decision. But my Lord knows, I'm sure from his judicial experience, that it happens in this jurisdiction, and it is consistent with the guidance given in the cases like Devasaline and BK Afghanistan, that the fact that the Secretary of State makes a decision and that decision is upheld on appeal is not a bar, and it's always open.
When it's relevant to the next decision. So if you have an asylum decision and then you have a human rights decision, there may be an overlap. But that isn't what the submissions are about. The submissions were, firstly, there had been an historic injustice, and secondly, if there had not been that historic injustice, your client would have been granted leave to remain rather than refuse leave to remain, and would have been here lawfully. And you've got to show that there was an injustice in the way the Secretary of State dealt with the first application, because this appeal is not about an application for Tier 1 status.
Lord, of course, for understandable reasons, is focusing on the phrase historical injustice, because that is how the submissions were framed. But the way I put it with respect is that a mistake was made in 2015.
What does that mean?
Well,
yeah, I think what it means is that your client says that the Secretary of State and then everything that flowed thereafter was mistaken in relation to his business.
Yes,
and that's it, isn't it? That's the mistake.
That
so
is.
In his view, that was all mistaken, but that's not what you rely on as the historical injustice.
Well, I put it in this way, that a mistake was made in 2015 in the sense that the Secretary of State and the tribunal wrongly took the view that the appellant wasn't a genuine business person.
Yes. And is that or is that not what you rely on as the historical injustice?
I do, but if I had drafted the submissions, I perhaps wouldn't have referred to what has happened as a historic injustice.
But you have to rely on that because your
Yes.
whole case is that the tribunal should have looked at these submissions and didn't. You can't say you've come along now and you thought of better submissions. So unless you can establish that the submissions
Yes.
would have made a difference,
Yes.
it's not enough to say I've got a better idea now. That
No, I
can't
see
work.
that. I see.
You've got to look at 109 to 111.
Yes.
Page 109 to 101, 111. That's where the previous council, although he tries to put forward matters to do with the pregnancy, that's historic now. He had no permission for that, and in any event, the baby's now been born, and we hope as well. But you've got to look at 109 and the
Yes.
submissions that were put to show that there's been that these submissions, which were the ones that were not taken into account,
Yes.
would have made a difference. Not different submissions.
Well, the key point is at paragraph 21 of those submissions. Page
Well, no, you've got to
110.
look at 18. You've got to look at them all. I know you're sticking to the point about the business, was it genuine or not, and that is one of a number of things that have to be looked at. But look at 18. In the appeal to the FTT, it wouldn't overlook the fact that the tax registration wasn't there. Then the last sentence begins, it also found that the business was not genuine. So you've got to overcome 18 as well, haven't you? And what your client was trying to do in 18 was to produce documents now in this appeal, which were quite not the ones before the Secretary of State in 2015.
And the purpose of that submission was to invite this judge to depart from the 2015 decision and to conclude that, contrary to the view that was taken earlier, the appellant was a genuine business person.
But he
Even if
still
they
wouldn't
did-
have done the tax document. And it's both that if you look at 90, it's now perfectly clear that the two issues resolved against the appellant were in the light of the evidence now properly before the FTT. So you've got to overcome the tax point as well as the business point.
Well, if you, I mean, I'm sure, Lord, you have seen the initial, the 2015 First Tier Tribunal's decision.
Yeah.
And my submission is that the underlying reason for refusal of that application and the decision of the First Tier Tribunal was that the appellant wasn't a genuine business person, and what the appellant was seeking to do in the 2020 appeal is to say, by relying on the new evidence, that he was indeed a genuine business person, and the decision that was taken in 2015 was wrong. And his submission was that is a matter that is material when it comes to the proportionality exercise under
I
Article 8.
couldn't, even if he was right about all of that, and it could be shown that he was precluded by Section 85A, now repealed, from curing the position before the First Tier Tribunal on his original appeal. I can't at the moment see how you could utilise that information, even if the tribunal accepted it, to grant him an immigration status that he didn't have in 2015, so that he would be put in the position as if he were here legitimately for 10 years.
Well, there is. I'm sure lady has picked the reference to the upper tribunal's decision in the case of Pradale from the papers. That was the case where the upper tribunal's presidential panel reconciled the earlier authorities on the subject, and in doing so, sought to clarify the circumstances in which the broad phrase of historical injustice can be used. And within that decision, the president gave examples of cases where the Secretary of State had a particular policy at a particular point in time. The appellant wasn't given the benefit of that policy due to an error, and it later emerges that the appellant should have been given the benefit of that policy.
That's not this case.
No,
There was no policy. In fact, the rule was you can't put in fresh evidence before the First Tier Tribunal. So the Secretary of State has acted entirely in accordance with such policy as there was. So it's the mirror image of this case.
True, but in absence of the documents that the appellant had, which he wasn't able to adduce to the First Tier Tribunal, the judge took the view that he wasn't a genuine business person.
No, you keep saying that. Unless you disagree with me, there are a number of requirements under the point-based system. You must get certain points, and there are certain non-point things you must satisfy. And if you haven't got the documents, and there are a number of documents, there's contracts that are properly dated, there's bank statements, but those were allowed in, and there seems to be in the corporation document, you can't get it. You're not entitled automatically to get Tier 1 status because you claim it. You must make an application supported by documentation, and if you haven't got the documentation, that's the end of it. In addition, even if you've got the documentation, and the Secretary of State has doubts about you and does, as she did her internet searches and so on, she may think you're not credible, and the tribunal may say, well, there's a huge discrepancy. You've shown us figures for a few thousand a year, and yet you say it's £147,000. But it's not enough, is it, Mr. Malik, to say he would have got it, but for the view that you say was mistaken about the genuineness of the business. He still wouldn't have got it. The Secretary of State would still have had to refuse it if he didn't put the documents in. Isn't that the case under the rules?
Well,
is it the case under the rules that he'd have had to be refused without the relevant documents listed in 41 SD, whatever it is?
no, that is correct. Subject to
So it is correct. So he wouldn't have got it.
But subject to one point, of course.
Yeah.
This hasn't been a focus of the appeal so far. But subject to
Well, it's the focus of the immigration of the submissions that you say were improperly left out of account.
yes, subject to one point, which is that Milord, I'm sure has picked the reference to the evidential flexibility and fairness in
Yeah, but the policy of the evidential flexibility was that if you could see that there were documents missing, for example, if it's a run of bank statements, it's obvious that one's been left out when you photocopied it. The evidential flexibility applies to that, and it was applied here, and it covered the bank statements because they didn't cover the original relevant 90-day period.
Yes.
But it wouldn't apply to the failure to produce the corporation tax documents or to the fact that the contracts that were produced did not have the duration stated in them. Those would still have been documentary failures that couldn't have been overlooked under the points-based system, unless I've misunderstood the system.
No. The point of the evidential flexibility in the rules was that if there was some other good reason for refusing the application, then the Secretary of State wouldn't ask an appellant to provide the missing documentation. And that is what, in my respective submission, the first judge in 2015 was seeking to say that there wasn't any unfairness in the decision-making process. And in my respective submission, again, I of course know what Milord.
Well, I'm looking at paragraph 29 on page 157. Sorry to be difficult, but you've got to start with the submissions, and you've got to go back to the rules, which I have in their current form, and you've got to look at what it is. I find that the appellant, and this is after the submission, that you couldn't look at the new evidence, there's material that wasn't with the application to the Secretary of State. He's produced evidence that cannot be admitted. It wasn't evidence that was available to the decision maker. This includes the correspondence corporation tax, that apparently was required.
Yes.
It included stamped bank statements and further evidence as dated in the bundle produced, and that is a reference back to the contracts not being dated. He failed to show that he meets the requirements.
Yes.
The only matter that he allowed in was the further bank statements, which showed the missing 90 days, or the missing bits of the 90 days. And those bank statements was a matter to which the evidential flexibility rule could apply, but he still wasn't prepared to accept that the others were covered by it, And then he goes on, I have further considered the non-point scoring attributes. And then he places weight on the discrepancy. But unless I misunderstood and you say I haven't, your client wouldn't have got Tier 1 status because he didn't put in the documents. And if it was said that the judge had misapplied the evidential flexibility rule, that would have been the subject of an appeal, or it would have been the subject of the JR, but we've got nothing to suggest that that was the case. That the challenge was put on the basis that the tribunal judge had misapplied or misunderstood the policy.
No, Lord is with respect right. So that is the position. So the appellant did not submit the required documents to the Secretary of State. But his case is that he had those documents and sought to submit those documents in the 2015 appeal.
It was too late by then. You've got to put them in with the...
Yes, and the 2015 tribunal dismissed the appeal correctly for the reasons that those documents could not have been submitted. I accept that. But my submission with respect is that when it comes to an articulate appeal and the assessment of proportionality, then the fact that the appellant had the relevant documents but could not submit those documents with his application.
Did not, rather than, you said could not.
Yes, did not submit those documents.
Yeah.
In my respectful submission, that cannot be regarded as irrelevant. In my respectful submission, that is a relevant consideration when it comes to the assessment of proportionality. One properly directed first-tier tribunal judge can say that I am satisfied that the appellant had those documents. He did not those documents for these reasons. And I accept that the appellant is a genuine business person.
That wasn't what the argument was in the submissions. And how can it be relevant? It can only be relevant to show that he should have leave to remain during that period. And the fact is, if he didn't go through the right rules, he didn't have leave to remain. Leave to remain is what you get if you satisfy certain criteria, and he didn't do it. It's no good saying he could have made an immediate new application in 2015, produced the relevant documents on that second application. None of that happened. As my Lady Justice Andrews says, he simply didn't have leave to remain. He was here unlawfully. That's the fact that's relevant to proportionality.
Yes, but in the submission is that quite apart from that fact, this is paragraph 21 of the appellant's submissions, page 110. Quite apart from that fact, the fact that he was running a genuine business, was generating the income, had invested a large amount in the business was all relevant.
Well, you have to read it, Mr. Malik, in context of para 23, which says, as a result, the appellants have wrongly been made overstayers. I mean, the argument is that because they didn't put in the documents but could have done, if they had put in the documents, they would have got leave to remain, and therefore they would have been here for 10 years legitimately, but they didn't. And as my Lord says, in a sense, they've only got themselves to blame for not doing it. The answer would have been to have made a fresh application for Tier 1 status.
I do not disagree with any of the observations that are being made. I cannot submit that the appellant overstayed because the Secretary of State made an unlawful decision. That isn't a submission that I can properly make. But the submission that I make with respect is one that I've just made, that quite apart from that matter, which is dealt with at paragraph 23, the fact that the appellant was running a genuine business, was generating an income, had invested in the business was all relevant when it comes to the assessment of proportionality. That is something that in my respectful submission was ignored altogether, because the relevant submissions were not before the First Tier Tribunal judge. The First Tier Tribunal judge and the Upper Tribunal took the view that it wasn't open to them to reach a different conclusion as regards to the genuineness of the appellant's intention.
They couldn't reach a different conclusion as to whether or not he'd been granted leave to remain in 2015 because he hadn't been granted leave to remain in 2015.
No, and that.
Or they could have reached is a conclusion that if they had the application in 2015, they would have reached a different decision. And the answer is that wasn't their job, and they weren't looking at a Tier 1 application in 2019 either.
No.
So how did it help?
Well, it helps in this way that if on the evidence the judge in the 2020 appeal had concluded that the appellant, contrary to the conclusions reached earlier, was a genuine business person.
And should have been granted leave in 2015.
No, you ignore that point altogether, because I have conceded that.
Well, okay. So the First Tier Tribunal should have taken into account, irrespective of whether or not he was here unlawfully or lawfully, that he was running a business and that helped the country and so on. Is that it?
No, and the fact, my lord, with respect that he did not submit those documents for the reasons that the appellant was seeking to provide in the evidence. So a judge could conclude that the requirements of the immigration rules were not met in 2015, but those requirements were not met because of a technical or marginal or consequential reason, and to take that into account in
What do you mean by marginal or consequential reason? He either meets the rules or he doesn't. And either you're trying to say he should be treated as being lawfully here between 2015, or in fact 2017 when his appeals rights exhausted, and 2019, or you're not. And if you are, then it's difficult to see the basis of it. If you're not, then what you're saying is one of the factors that the First Tier Tribunal could take into account was the contribution that he was making to society at large by running a business. Problem is, that wasn't his
see, to give an example, just to illustrate my point, there is a rule, as the court knows, that if a person resides in the United Kingdom continuously, lawfully for 10 years, that person gets indefinite leave to remain. Now, there is a gap in the lawful residence, and for that reason, the appellant is unable to qualify for leave to remain. Now, the appellant, at the appeal to the First Tier Tribunal, provide reasons as to why the gap occurred.
The gap occurred because, quite correctly, he was refused leave and didn't have leave.
Yes, but if the gap was for the reasons, for instance, that he was unwell, he couldn't make an application in time, he had to go abroad to see a dying relative and so on and so forth, then all that in my submission is relevant when it comes to the assessment of proportionality, and a properly directed judge can say that you do not meet the requirements of 10 years rule because you have this gap and technically the requirements of the rules are not met. But I'm satisfied that there was a good reason why there was non-compliance with the rules, and that is something that is relevant and material when it comes to the assessment of proportionality. In the same way, and there can be a sort of catalogue of examples. A spouse who is seeking entry or remain is unable to meet the minimum income threshold, but there is a good reason as to why the person is unable to meet the minimum income threshold. The judge will dismiss the appeal under the rules, but can take the non-compliance, the nature and degree of non-compliance with the rules, and decide the Article 8 claim having regard to it. Precisely in the same way, in my respective submission, the tribunal in the 2020 appeal could have taken into account the fact that the appellant was a genuine business person. He wasn't able to meet the requirements of the rules in 2015 because of a mistake or an error that was unintentional. And then to make a decision on whether his removal from the United Kingdom would be disproportionate having regard to all those factors. Now here, the position
So
is that,
are you stepping away then from the historical injustice issue completely?
no, I'm not. I say with respect that that is something that falls within the argument, within the submissions that were put.
I can say, I mean, it seems to me what you're actually saying is, well, never mind all that. The fact is that he was a genuine businessman. It was all a bit of a muddle at the time, and that the judge therefore should have taken all of that into account in the proportionality exercise and ignoring everything that had gone before. Well, that's not the same thing as saying that what happened in the first place was was an injustice. It seems to me that I can't quite see how that follows from what you're now submitting.
Yes, lady, can I take my lady to tab 8 of the authorities bundle just to assist my lady with that point. Sorry, not tab 8. This is tab 4 of the authorities bundle.
Patel.
So this is where my lady will see the presidential panel's decision in the case of Patel. Now, may I take my lady to page 15 of the
Well, first of all,
authority?
you're not claiming this is an historic injustice in the sense of your client belongs to a class of persons like the Gherkin. It's not that kind
No,
of thing.
not that
You
case.
can leave that to one side.
Yes, so if you go to page 15, you'll see a heading historical injustice.
Yeah, that's what you're relying on, yeah.
So you'll see that the phrase as it is understood and applied in this jurisdiction is not restricted per se to instances where there has actually been some clear injustice. You'll see the various examples that are given. I mentioned one.
You've got to read 42 first, haven't you?
A few minutes ago, yes, where there was a policy that wasn't applied, paragraph 45, where there was a delay.
No, you have to read paragraph 42 first because these are examples of the general principle.
The problem from your perspective, from your client's perspective, Mr. Malik, is that whatever happened cannot be described as being the result of the wrongful operation or non-immigration by the Secretary of State of her immigration functions. The Secretary of State has properly applied her immigration functions throughout. As a consequence, perhaps maybe a harsh consequence, of the fact that your client didn't get his ducks in a row and produce all the relevant documents to the Secretary of State at the requisite time. Now, one can see that it may be very sad for him that as a result of the policy that obtained at the time, he wasn't then able to cure that position by putting those documents before the First Tier Tribunal. But that was how the law was at the time. I can't see how one comes within that principle.
Yes, lady, if you have paragraphs 42 onwards,
Yeah.
the detailed discussion of the case. If you wish to see a summary of the decision, it is on the second page of this decision. In the judicial head note historical injustice, and you'll see that the phrase is not limited to instances where there is a wrongful operation by the Secretary of State of the immigration functions. The phrase, the broad phrase as it understood and applied in this jurisdiction can apply to a number of instances, and they include where there is a delay or where the Secretary of State forms the view about a person's activities or behavior, where that view turns out to be mistaken.
And you've gone and dealt with you say, was it a credible business? But again, I'd ask you to explain to me how you can put the lack of documentation within the phrase where the Secretary of State forms a view about an individual's activities or behaviour, but where her view turns out to be mistaken. Because her view that he hadn't submitted the documents wasn't mistaken.
No, it wasn't. But that particular bit of force applies to the view that the appellant wasn't a genuine business person.
That's only half the question.
That's the half of it. The other half I seek to meet in this way, that if the requirements of the rules are not met for a particular reason, then that reason a judge is fully entitled to take into account in deciding.
As an historic injustice.
Well, as
Rephrase it, where the applicant, through his own failures, does not obtain leave to remain, but the applicant, if he had not made those mistakes and made proper application, he might have succeeded. That too is a category 5 years later or 4 years later that gives rise to historic injustice. Is that the submission? It has to be given the way that the submissions were put.
That is, the submission that I make with respect is that it is one of the points that was made in the submissions, and I cannot make I cannot make a submission that the appellant became an overstayer because the Secretary of State took an unlawful decision because she didn't, and that's how I put the argument. And
Well, I can see, Mr. Malik, that on the basis of paragraph 46, if the sole basis on which he failed
yes,
was an adverse view of his business, then you might at least have the glimmer of an argument. The respondent has formed an adverse view about his activities or behaviour, and if that had been the reason why the adverse immigration decision came about, and it turned out that she was factually mistaken, that might be fine. But as my lord says, the real problem is that it wasn't just that, it was the documentation.
Yes, and you say it's all part of the same thing.
Yeah.
that is the submission, and
Yes.
that is the extent of the submission that I can realistically
make
make on this particular point. And of course, I'd prepared to argue the more interesting legal arguments, but I suspect that the court is not minded, at least at this hearing, to receive submissions on proper construction and procedure to be adopted as to what constitutes a new matter. So unless I can assist the court any further, I don't think that I can add anything to what I've said on this particular issue that is troubling the court.
Thank you, Mr. Malik. I'm conscious that there's been a lot of intervention from the bench, and I would like to be confident that you've put before the court all the arguments that you wanted to put before the court on this particular issue.
Well, Milady, if Milady is kind enough, then I would be very grateful for just a couple of minutes, just to have a very quick word with my junior and my instructing solicitor, just in case if I haven't missed anything obvious.
Yes, of course.
Very grateful. I'm very grateful for the opportunity. The point that I'm asked to emphasize is that in the 2020 plea, the appellant sought to provide an explanation as to why he wasn't able to submit all the relevant documents in 2015. He had written to HMRC did not obtain, wasn't able to get hold of the correct documents, wrote to the Secretary of State saying that he's waiting for those documents. The Secretary of State nevertheless made a decision, despite being on notice that the appellant was seeking to obtain those documents from HMRC, resulting in an adverse decision. He couldn't adduce additional documents to the First Tier Tribunal, and the appeal failed. So this simply reinforces the point that I was seeking to make, that there was in the evidence an explanation, a plausible explanation before the judge in 2020 appeal as to why there was non-compliance with the rules in 2015. And the submission is that was something that was relevant when it came to the assessment of proportionality. It was ignored altogether because of the legal errors that the First Tier Tribunal and the Upper Tribunal made. And if the Upper Tribunal had not made those errors, if the Upper Tribunal had not held that those matters were new matters, and the First Tier Tribunal was not entitled to depart from the earlier decision as a matter of res judicata, the submission is that a different decision could have been taken. And for that reason, I submit that the procedural irregularity which the court has assumed for the purpose of this argument is material to the outcome.
Thank you very much indeed, Mr. Malik. We'll rise.
Okay.
Court rise.
Okay, yeah, so I guess we'll finish in half a day, yeah.
We just keep this streaming running, it's just for 2 minutes.
Mr. Evans, we don't need to trouble you. Thank you. We dismiss the appeal. The reasons for dismissing it will follow in due course in the usual way. The judgment will be provided on the usual terms for any corrections as to facts or typographical errors and matters of that sort. So far as costs are concerned, we assume the parties can agree that. If they can't, we'll expect short submissions, no more than 2 pages from each of you, and we'll determine that in advance of hand down. Mr. Malik, thank you very much for your submissions today. Will rise.